Hi, I've had a ton of clients ask me, Dawn, what's the difference between a will and a trust anyway? So I've made this video to try to answer that question. The Revocable Living Trust, or Inter Vivos Trust in Georgia, is a substitute for a last will and testament. Dawn, stop talking like a lawyer. Speak English, please. Okay. So a will or a trust are both documents that you use to get your stuff to your loved ones after your passing. So the process is very different between the two. So I'm going to highlight some of the differences between the two of them. So a will, once you've passed away, has to be filed with the court. Unlike a will, a trust does not get filed with the court if you've passed away. A will in Georgia must be approved by the court, but the trust, by contrast, does not get filed with the court and so doesn't have to be approved by the court. With wills, there is a notice that must go out to your closest relatives to ask them if they want to object. With a trust in Georgia, you don't do that. There's no notice to the closest relatives. The only people who are entitled to any notice are the people who are included. In Georgia, if you need to use a will after someone's passing, that process can be very time-consuming. From the time you pass away to the time that the executor actually has authority to act might be 6 months or 12 months or even longer, depending on what's going on. It's very common for it to take 6 months. A trust, by contrast, does not have that process because it doesn't have to have court approval. It is very streamlined and very rapid. Essentially, your trustee can jump in and start doing what they need to do as soon as they can get proof that you've passed away. So that might just be a couple of weeks. In Georgia, a will is a very public document once it's filed with the court. So if you've passed away and somebody had to file your will with the probate court, most of the probate courts in Georgia are uploading all of the documents filed with them onto the internet. So that means that any wacko with a computer can look at the contents of your will, they can see who your closest relatives are, they may be able to see what the assets are as well. A trust, by contrast, is a very private document. It's not filed with the court, it's not uploaded to the internet anywhere, and so no one is entitled to see the contents of the trust or what assets are in it or who's included, except for the trustee and the people who are included. So it's a much more private document. So let's talk a little bit about this in a more concrete way. So there may be assets that you could send directly to a loved one by beneficiary designation if you passed away, but I'm going to use an example of something that you can't do that way in Georgia. So in Georgia, if you have a piece of real estate, a home that you wanted to leave someone, then that can't be done with a beneficiary designation. So we have to either use a will to get it where it's supposed to go, or maybe we use a trust to get it where it's supposed to go. So let's just say you want to leave your house to Sally. You've passed away, your will says the house goes to Sally. So your executor would have to prepare a petition and submit that along with the will to the probate court. And then the judge will look everything over, send out notices for a potential objection to your closest relatives, and then they might decide to appoint the person that you've designated as executor, or they might decide that person's not suitable, I'm going to appoint somebody else, and that's their prerogative. Or they might look at your will and say, it's not valid, we're not going to accept it. Or one of those relatives might object, and then everything slows down. There's a 6-month period where people can file things and file objections and requests for information. So things can go very differently with the will process if we want to rely on that. By contrast, let's just say that we put the house in the trust during your lifetime, and then you've passed away. The trustee gets documentation that you've passed away, and then they step into the role as trustee right away, and they pay any bills that are necessary, and then they can go about distributing the asset, the house, to Sally very quickly. It might just be a few weeks. So it's a very different process. So that kind of, in a nutshell, is some of the differences in how wills and trusts operate in Georgia. Is a trust right for everybody? No. There are lots of people where it might not be a good fit. But there are lots of people who prefer it, and lots of people who it is a good fit for. So I hope that you found this video helpful, and I hope you will subscribe. We're going to do lots more videos in the future where we do deep dives on this topic and other related topics. So feel free to subscribe, and we'll keep you informed on this topic and others related to it. And if you are interested in more information, you can contact me, Dawn Levine, at Georgia Wills, Trusts, and Probate Firm, where we could do a no obligation consultation to talk about your specific situation and whether a will or a trust might be a better fit for you. So at Georgia Wills, Trusts, and Probate Firm, this is all we do. This is all we've ever done. So we would love to talk to you. The number is 770-795-4992. Again, that's Dawn Levine at Georgia Wills, Trusts, and Probate Firm at 770-795-4992. Thanks for watching.